to start with, I'm going to just give a little bit of background, just a short potted history about who Bermans are. Hopefully you can see my screen now.
Yeah, I can see that.
Yeah. Okay, so it was really just to take you through who Bermans are, what we do. It's only going to be a couple of minutes, and then I'm going to introduce our two speakers, Rob and Stephen, explain what their background is and the areas of law they cover. And then we've got some questions that we've received in advance, but you're more than welcome to use the chat function to ask your own questions as we go along. And Rob and Stephen will try the best to answer them. So if we make a start now, so the background, so I'm going to start with the history, run through sort of clients we work with, a little overview of the firm, and then a bit of background on the speakers, and then we'll fire into the questions. And then at the end, I think Louise is going to come back on future sessions, and we've got some ideas about doing some more specific areas of law. Really just looking for some feedback, if you could come back to us. So about Bermans, we were founded in 1970 by a gentleman called Keith Berman, who's still going, lives in New York, founded his firm over there as well. And he basically revolutionized the debt recovery industry in the UK. He was the first person to link the courts with technology, and he quickly acted for most of the institutions, and Berman's developed a real national reputation in leasing and factoring. We've later added the full commercial areas of law, and we celebrated our 50th birthday last year. It was kind of put into the quickly stopped by the COVID outbreak. We had a load of events planned, but that put the kibosh on that. But hopefully we'll resurrect that at some point. But we do that for all sorts of different clients. There's just a flavour there. We act for financial institutions. You might see some names on there like Lloyds Bank and Aldermore. We do also work with big institutions like housing associations, Trafford Housing Trust, Forviva. We also act with some big education companies like UCLan, University of Central Lancashire. But mainly we act with owner-managed businesses and SMEs. So, these can be in different industries. There's HM Ventures there that are hauliers. There's David Pluck that some of you might know, that's a bookmaker. So in the retail sector, we act for property people. So BXB there, they do promotion agreements for residential housing sites. So, it's quite a vast range of different types of businesses, shapes and sizes. But the bulk of our client base is around the Northwest, I would say, although we do work on a national basis for the finance areas. So this just gives you a flavour. We've got 2 offices, Liverpool, Manchester. There's about 70 of us. There's 15 partners spread across the 2 offices. And we kind of focus on these 2 main areas. This is the niche services there. The asset finance is the leasing. The invoice finance is the factoring that the firm was kind of founded on. And then the full commercial service offering that's been developed kind of covers everything that a business person would need, from sorting out the premises, arranging contracts of business like Stephen would get involved in, looking after your staff, which is the employment area that Steve would do. Also corporate buying and selling businesses, and litigation for when you're in dispute with people. And we've also recently added a sport team. So we have an ex-Premiership footballer, Gareth Farrelly, who's qualified as a solicitor, and he works with a chap called David Keenan, and they both specialise in the sports field, offering commercial contracts in that area. And yeah, so quite a rounded offering. And then I just wanted, so today we're going to kind of focus on 2 chaps, 2 good-looking chaps that are on there, Robert and Stephen. So Rob really is involved in employment, and his background, he's been a lawyer since 2008. He acts for a wide range of clients, from OMBs to large international companies. and he advises on internal HR and employment law issues, as well as business reorganisations, restructures, 2P transfers, also dealing with director duties and dismissals. And he's experienced as well at dealing with employment tribunals, and appears as an advocate. Okay.
I wrote that myself, Colin.
Yes, good, very good.
There's a lot in there. I'll have to reduce it down next time.
I know. Stephen's is a bit shorter. Stephen's, we're pleased Stephen's come on the call today. He's only been with us 6 weeks. Again, like Rob, he qualified as a lawyer in 2008. So, you know, he's been a lawyer a good 10 years plus. And he deals mainly with all types of commercial contracts and arrangements. This can be agency or distribution, confidentiality, consultancy, event management, outsourced services, sponsorship, software and website development. I'm sure he'll get on to more of that as we go along. And again, his skills are transferable, and he acts in lots of different sectors: cosmetics, manufacturing, pharmaceutical, leisure, retail. So I don't really have any more. I just thought I'd introduce Stephen now, and he can come and talk to you about some questions that we've had in, just about commercial areas of law. But as I've said, if you could use the chat function and ping any in, we'll try our best to answer them today.
Okay, over to me then. Yeah, please, if you do have any questions, then fire them in. I think we've got 4 on the list that Colin and I and we've received, but by all means, any time you want to interrupt or pick up anything, then we can answer them rather than necessarily just going through the ones that we've got here. The first question that we've got is, what is a trademark and how can it add value to a business? You're probably all aware of or have seen trademarks, brands and logos. A lot of big retailers in particular really value their trademarks and brands and logos, and it can really add some real value to a business. You just have to look at someone like ASOS, for example, and a lot of what they do is built around their brand and trademarks. So trademarks themselves are a form of intellectual property. They are seen as a monopoly or an exclusive right. So if you have a trademark that's been registered, then you're the only one that's able to use that right, and no one else can without your permission or an express license. There are a number of different types of trademark. You can register just a name on its own or a word mark. You can register a brand or a logo itself, which might be a quirky design or potentially even a color, which I know someone like Orange has tried to do in the past. So it is quite flexible, but there are a number of rules that you need to kind of adhere to before you can have that trademark registered. You have a trademark registered at the Intellectual Property Office in the UK, but there are also trademarks and registries throughout the world which you can also use to register a trademark. So you have to go to each individual country to have your trademark registered. They're relatively cheap to have them registered as a starting point. Typically, you can get a trademark registered for anywhere kind of between £1,000 and £1,500. I would very strongly recommend them when you're starting up a business, particularly if you are looking to enter into the kind of consumer space. Having a trademark is really useful, and that can be really add some value in the future to the business. A lot of people will not only register them at an early stage, but come around to sell them in the future. And as I said, you can license them out to other brands or logos and charge a royalty or a fee for that. So they are important, and a lot of businesses, particularly in the consumer space, are valuing them almost more than necessarily they would their kind of more tangible assets, like their machinery and bricks and mortar. So that's the first question. Sorry, did I see a question pop up there? Can you?
Yeah, I think there was one, Stephen. Yeah.
It doesn't.
come up on
Are you
there.
okay to read it out, Colin?
I can read
You're
it.
on
Yeah.
mute, Louise.
Yeah. So, I mean, I don't know if Laura, if you want to ask that question yourself.
Yeah.
Yeah. Go on.
Okay, cool. So it says, what are some of the major changes you've seen over the last 10 years in commercial businesses, mainly relating to data and privacy?
Yeah, I think a lot of
Question.
yeah, but I think a lot of things, certainly in the last 10, 15 years, kind of picks up on something I mentioned there, which is moving from more what I would call kind of tangible assets. So your bricks and mortar properties, your machinery, your stock. And 10, 15 years ago, a lot of businesses were around protecting them. Now moving kind of forward the last 10, 15 years, a lot of things have moved into what I would say more intangible assets. So things that you can't necessarily touch or move. So things like trademarks, software is another one that's become over the last 10, 15 years, a lot of businesses are investing in. And then as Laura mentions there, data and data privacy. I think 10, 15 years ago, people were aware of the value of data and how it can be used. But I think these days, a lot of businesses, particularly in the retail consumer sector, almost data has become just as big, if not a bigger asset than the old school bricks and mortar. And what you can do with data and how you can generate value from data and data analytics and insights and all those sorts of things has just kind of skyrocketed in the last 10, 15 years, which has meant that businesses, particularly, and we'll come on to my next question, which is around GDPR, particularly with kind of the changes to data protection legislation, people are having to be a lot more aware of what they can do with data and how they can use it. I think kind of 10 years ago, people kind of did what they liked with data and didn't really care. Now you have to be a lot more cautious. The rules, particularly around data protection legislation and GDPR, have made it so that you can't be as maybe reckless as businesses were 10, 15 years ago when it came to marketing. There are a lot of rules, and I know marketing teams hate some of the rules that come in place when you talk about data protection and GDPR, but it has been a massive shift, I think, for over the last 10, 15 years. And I said, you look at the likes of ASOS and Boohoo and Amazon, a lot of their business is now driven around intangible assets. It's driven around data. It's driven around how they maximize the value from their data, but also it's driven around their intellectual property, both in terms of the software and the website, but also in terms of how they use their trademarks and brands to get kind of real market penetration. And I think that's a massive change from where 10, 15 years ago, people were only worried about their office space and their factory and those sorts of things. So I think that's been a massive change over the last 10 years.
Okay.
Great. Thank you. Sorry.
I was just going to say, do the second question.
The next question then, Colin, and hopefully I can link that into Louise's question as well. So GDPR, you may or may not be aware, but May 2018, GDPR came into place. It was a massive change in the data protection legislation, particularly in the UK, but also wider in Europe. So GDPR basically brought data protection legislation into the 21st century. Previously, we were relying on the Data Protection Act 1998, totally outdated for what was going on in practice. GDPR came in and basically changed how people could use and handle personal data and what they could do with that personal data. And a lot of it was focused on making sure that people's personal data was kept secure. It wasn't easily transferred. People weren't easily selling data and then using that for marketing purposes. So yeah, GDPR, May 2018, for those that were involved in any business, I think at that time was a real focus for them. Since then, as I've alluded to, GDPR was a piece of European legislation that came out of the EU. Since then, we as the UK have left the EU, so there has now been a kind of divergence of what was GDPR, and now we have what we refer to as EU GDPR and UK GDPR. So it's the same or very similar, the UK and EU GDPR. There has been this change, but a lot of the rules are still applicable in terms of GDPR and how it applies. I don't think there's necessarily been a slip back in the last 12 months. I think it's still a focus for a lot of businesses, and a lot of the stuff that I've actually been here in the last 6 to 7 weeks has been around GDPR. I think there was a massive kind of push in 2018 to make sure that everyone was GDPR compliant. And now I think it's kind of eased off in terms of the people that have already got those policies and procedures and all the requirements in place. But I wouldn't say that there's necessarily been that I've seen in the last 12 months, a massive shift away from that. I think if anything, with Brexit, GDPR has almost become more a focus. And I think people were under the misconception that because we'd left the EU, GDPR no longer applied. So, but that's wrong. GDPR does still apply in the UK, and there is legislation that now supports that. What has recently happened, actually last month, is that the UK is now deemed adequate for the purposes of EU GDPR, which you might say, well, that makes no sense when we actually comply with GDPR, but the EU have their ways when it comes to data and making sure that they have the necessary protection. So the UK is now adequate for the purpose of the EU GDPR, which means that we can freely disclose and transfer and process data between the UK and the EU, despite being outside of the EU. Okay. So that from a kind of compliance point of view is good, and means that if you are trading in the EU and transferring data in the EU, then there is still that flexibility to be able to do so.
Okay. Stephen, we've had a question from Rebecca. Can you see that?
Yeah.
I know you would probably say we probably could do a whole session on GDPR and privacy in the future. So maybe if we could just limit it to just this answering this other question from Rebecca, because all we want to do is give an overview at the moment, but we can obviously go into more detail after this session, but you could be on all afternoon otherwise.
Yeah, it's an afternoon all day thing, GDPR, and I say particularly even more so these days when data is becoming so valuable to businesses, and a lot of businesses are being driven around data. So yes, the e-privacy regulations are again still apply in the UK, even though we're outside of the EU. A lot of kind of in simple terms, all the kind of rules and regulations that we were governed by when it came to the EU still apply, and Rob will probably touch on some of those in his speech about kind of the employment regulations. But yes, the e-privacy regulations are still applicable, and you still need the relevant consents, etc., to market people. Is it one to watch? Again, yes. I think the government has said, particularly kind of post-COVID, that they are going to look again. Post-COVID and post-Brexit, they're going to look again at how data is used by businesses. I say particularly when it becomes a bigger an asset for a business, and I think that they will look at it again. I wouldn't surprise me if in the next 2 or 3 years GDPR and UK GDPR is changed by the government, because I think there is a real shift to making sure that people's personal data is protected. And I think that it is something to watch. It's something that will change. I don't think that the government necessarily wants to keep it on the back burner in any way, shape or form. So I think it is one to watch 100%. And particularly when it comes to kind of marketing to individuals and direct marketing in particular. And I think, the reason I think it will change is because the technology is changing, and marketeers are getting cleverer with how they get around GDPR and how they market to consumers. So I think the law will have to carry on changing when it comes to GDPR, because I think that there will be a need to keep up with pace of what marketeers in particular are doing, and businesses like Amazon, Google, etc., and how they're making their money from them. Cookie policies, so I'm just picking up Rebecca's question, cookie policies and cookies themselves, it's not something that we actually see a lot of, cookie policies. I think that, and cookies generally, I think it is something, again, that the government will look at, because it's all a way of generating more data. But the rules are not dissimilar to they are in terms of GDPR and getting the consents and being able to getting people to opt in and opt out. So again, I think cookie policies, that it is something that people will have to watch out for. And again, I think it will be come down to a shift in government policy and the law when you're looking at data and data transfers generally. Any more questions on GDPR and data? Colin, I don't know whether, I'm just conscious now of time, whether the other two that I had we want to quickly run through, or whether it's over to Rob.
Look, Louise, how are we doing for time?
Yeah, I mean, if you want to quickly, I know we're going to do a bigger session on the GDPR and the privacy and everything, but happy to quickly go through. And if we send any other questions we've got for Stephen separate, then I can always send them on to you. So that might help you with time.
No problem.
So if you just want to touch on terms and conditions, then.
Yeah, these two are probably not quite as exciting as the first two, certainly for what you guys do, but they're very important when it comes to a business and operating a business. So, I mean, the first thing to say about the benefits of standard terms and conditions, and particularly when you want to get paid by your customers, is making sure that there's clear payment terms, and they're set out from the outset what your payment terms are. Now, whether that's 30 days, whether that's 60 days, whether that's 30 days from the date of invoice, whether that's 30 days from the date of receipt of the invoice. A lot of businesses kind of avoid having contracts in place and standard terms and conditions, but actually what that ultimately does is it doesn't enable you to impose your payment terms on a customer, and therefore gives the customer greater flexibility later on down the line as to when they will or won't pay you. The other advantages when it comes to terms and conditions is around kind of some of the mechanisms that if someone doesn't pay you on time. So in theory, if someone doesn't pay you on time, you could still contractually be obliged to carry on performing services for them, even though you're not being paid. So the real advantage of having some standard terms and conditions is that you're able to produce or incorporate some mechanisms that cover off what happens if you're not paid. So if you're not paid, that may include a kind of ability to suspend your services, terminate your services, potentially charge interest and costs if you're not paid. So a lot of businesses, I think, try and avoid having standard terms and conditions, but they are really important when it comes to potentially not being paid or not getting paid on time, because it gives you both a clear mechanism for what happens if you're not paid, but also gives you, or makes the court process, if you ever have to sue someone for not being paid, a lot simpler and a lot easier. Next one, Colin. Thank you. And this is just a real kind of high level look at some of the things that you might want to consider when you're looking for an investment, or a business is looking for investment. The first thing to say is make sure that you're keeping proper records and documents. I think a lot of businesses think that they can, especially when they're growing and they're growing quickly, that actually documents and records become a little bit insignificant. And we've touched on some things already today, and Rob will in his presentation, about kind of contracts, making sure that you've got contracts and they're properly documented and recorded. IP, so if you have got trademarks, that it's properly registered and that the records of those registrations are kept. software, if you're buying in software, or you have any software that you've licensed, that records are kept on the terms of those software licenses, or records are kept on how that software is been developed and who's developed it, and do you have the rights to use that software. Rob, GDPR as well. There are a lot of things on the GDPR that you need to do to ensure compliance. You've probably all seen privacy policies, cookie policies. You need data transfer agreements if you're shifting data from one entity to another. All those things are important when it comes to compliance, and therefore is something that if you're ever looking for investment down the line, then an investor or their lawyers in particular will want to see. So I think the important thing here and takeaway is just to make sure that if you are looking for potential investment in the future, that any records are kept and up to date, and that you know where they're stored. And I think, again, touching on something we talked about earlier, 10, 15 years ago, these records were kept in a filing cabinet and a safe, and no one looked at them. These days, with everything moving online and the cloud and all that sort of stuff, that it's just a case of making sure these records are accessible and people know where they are.
Okay, thanks, Stephen. I think, shall we move on to Rob's bit?
Yeah, thanks, Colin. I just wanted to share with you, sorry about that, the kind of events that take place when you're doing a video conference from home. I had the window cleaner. I'm upstairs in my house, and the window cleaner came up on the window. I was like, all of a sudden there's a man stood next to the window, so I had to blank out the camera. But hopefully that's that particular window that's cleaned and done now. But if you see the camera go off, you'll know why. But yeah, I wanted to dip into employment law and the kind of situation as we stand in relation to the government easing lockdown, and a quick, as can be seen up by the slide, a quick look at terms and conditions, and separately hiring, because that tends to be the trend at the moment in terms of companies are either facing some form of financial difficulty, and that may be magnified by the government removing some of the subsidies, i.e. furlough. Or conversely, what I'm finding is some clients saying business is booming, we're doing well, and a quick look at the key points on hiring staff. So if you could refer to the first question, please. There we are. So why change terms and conditions? An employer may well want to do this and affect a change in terms and conditions because essentially it saves the employer some money, i.e. they can reduce the pay of their employees and redistribute those monies to elsewhere in the business where it is needed. An employer may also want to do that if they envisage a redundancy process. So as part of a redundancy process, an employer will need to show that they've acted fairly and reasonably and considered all alternatives to redundancy. And part and parcel of that is to show that prior to redundancy taking effect, they've tried to avoid a redundancy by changing terms and conditions of the staff, and that obviously hasn't been successful, leading to the redundancy. So there's two primary reasons why an employer would want to change terms and conditions as those referred to. Second question, please, Colin. So how do you do it? Three main ways of an employer changing terms and conditions. They can either do it by an employee's consent, which if an employee is in a situation where they understand, for example, where the company is in financial difficulty, they're more inclined to accept a reduction in terms if they know that the possibility of not doing so is redundancy or even worse, insolvency. And therefore, they're more likely to consent to the reduction in terms. The other ways of doing it is that an employer can look to vary the terms by a clause in the contract. There's usually something called a variation clause in contracts of employment. And they could do that. They could just push the change through. If it's a minor change, they can push it through by relying upon that variation clause. And the third way of doing it, which is gaining more kind of publicity, is something called dismissal and re-engagement. So employees dismiss under the old terms, the old more favourable terms, and re-engage under more inferior terms. And that's, as I say, a lot of kind of publicity at the moment, adverse, negative publicity, because employers are cotton on to the fact that it's the ideal time to do that if they can. And but it does mean ultimately the employees are worse off, and it's led to ACAS or submitting a report to the government. And it may well be that things change, that employers can't dismiss and re-engage in the future. But at present time, then there's no restrictions on that. So turning to the next question, is it safe to do? If you have an employee's consent, yes, because what both parties to the contract are agreeing to vary the terms, and then that change will be confirmed in writing subsequent to the event. Bear in mind that if you are changing terms and conditions, it's likely that you'll need to consult with the employees, and if it's over 20 employees that change the terms and conditions are affected by, then you'll need to enter into collective consultation. That is such a huge, wide area that I won't talk about it now, but those are considerations. In terms of varying, so if an employer relies upon the variation clause in the contract, again, if they're taking that action, then the variation should be for minor changes, such as changing pay date, for example. Because if it goes wider beyond that, then an employer can be in breach of contract, because what they're trying to do is change the terms and conditions that have previously been agreed, and it's a fundamental change. So that can lead to problems for the employer. Going back to dismissal and re-engage, that's the most risky for an employer, because effectively you're just bringing the employment to an end. You serve notice, you terminate employment, and then re-engage. However, it's unlikely that an employee will necessarily complain, because they remain in employment and they don't want to bring a claim against an employer while they're still employed. Also added to that is that there's still, let's say there's a reduction in pay, the employee will still be earning, so their losses may not be that significant. So you tend not to find many challenges on that basis. So I'll turn to the more cheery topic of hiring, and these are really kind of points of reference and points that you'd be good to take into account when you're going through the hiring process. So first and foremost is your job advert. Make sure that it's clear and doesn't contain anything that can have discrimination connotations, such as referencing or phrasing of energetic workers or highly experienced. The reason being that if, let's say, for example, a disabled employee is rejected and their disability prevents them from being highly energetic, then they can bring a claim on the back of that. So if you're ever unsure about the wording in your job advert, then get it checked, best to do so. But as long as you're clear, then that will help to avoid any sort of problems. Also, what I would say is set out your job specification. Job specs, so important, because it sets out what the employer expects of the employee. By the same token, it also sets out what the employee will be working to. So the employer will be joining the employer. They'll be slightly unsure as to, they may be slightly unsure as to what the parameters are or what they need to do. So having a well-defined job spec is will be helpful to both parties in ensuring that the future employment relationship between both is successful. So, and also in terms of the recruitment process, make sure that you keep notes of the recruitment process. So, for example, the job advert, the interview process, and any sort of correspondence or emails that are exchanged after the employee started employment. And I've had it in the past where employers haven't necessarily done that; they're just too busy, and that's fine. But if there is a challenge, it makes it a lot easier for an employer to rebut a claim if they've got a contemporaneous notes that highlight the decision making of the employer. And in fact, it wasn't tainted by anything to do with discrimination. There are other reasons why they came to that decision. So from that point of view, always to keep notes. So turning to the next point, please, Colin. Written employment contract, is it needed? Well, there's no statutory requirement per se to have a written employment contract, but there is a statutory requirement to have something called a statement of particulars. And most of you will be familiar with this. So it should contain such information as name and obviously the address, such information in relation to salary, notice, holiday, sickness, training now. So those should be contained. There is a specific requirement for the statement of particulars as to what it should include, and that was enhanced last year when the Good Work Plan took effect. So, but most statement of particulars will satisfy the legislative requirements. So, best to issue an employment contract, best to get a signed contract back from the employee if you can. Certainly, if it contains something called post-termination restrictions, which is anti-competition clauses, then best to get the signed terms back. My final point was really just to touch upon monitoring performance, and there is no question here. It's more of a statement, and it's more from an employee relations point of view. There can be so much effort and expense in taking someone on in the recruitment process, and if it goes wrong in the early stages, then it defeats the whole purpose, and it can then put the employer back. So it's important, obviously, if you've got someone on, if possible, bring them on. Monitor their early performance. Make sure that if they need some form of supervision, then that's provided for, or if they have any questions, that they're responded to. In terms of what I was going to say also is, if in the general wider scheme, if you are making decisions that could impact on the employee, then involve them in that decision making. Consult with them. The main problems that are incurred by employers when it comes to employment tribunal claims is that the employee will simply say, well, they didn't communicate with me and that left a bad feeling with me, or they didn't tell me what I needed to do. And having those levels of communication are really key, certainly in the early stages when the employee has landed. So and one other point I was going to say, in probationary periods, make sure you use your probationary period. If it needs extending beyond the 3 months, then do that. 6 months, 9 months, 12 months. It's really useful to keep the employee aware that they need to perform, but by the same measure, as I say, offer the support to the employee. And that was it really for what I wanted to discuss. There was also another point in relation to employee ownership trusts and how they're being increasingly used.